Welcome back to the second segment of this law session of public law dealing with sources of the Constitution. We did, of course, start off in the first segment by considering what sources there are. We looked at generally an overview, and in particular I focused on the statutes which have some constitutional significance, and certainly statutes do provide one of the biggest sources, or rather would be considered one of the biggest sources, precisely because it's coming out of Parliament. The cases, of course, do provide their own list or raft of constitutional cases, in inverted commas, to show that there are certain constitutional principles which are founded in the cases. And I finished before the break to say that what we'll be looking at when we come back is just to by way of a brief recap on the cases, and then we would carry on. The point is then that when you look at the case law does provide for some significant issues of constitutional law, or do provide a significant basis for some aspects of constitutional law. And I pointed you to a couple of these cases, Entick and Carrington, Liversidge case, and we do also consider GCHQ as being important. But what I also want you to bear in mind is that when it comes to EU law, there are certain significant EU case law coming out of the CJEU, the Courts of Justice of the EU, which are also very relevant because, again, they do provide a basis for certain constitutional matters. Now, when you look, for example, at, say, the Italian case of Frankovic and Bonifaci, which looked at when the concept of state liability may be incurred as it relates to a breach of EU law obligation, again, this is something where a citizen may have a right, where a state may be liable to that citizen for a breach of a statutory duty it owes a citizen by virtue of its obligation it has under EU law. Again, arguably, we see that the case law coming out of the Court of Justice of the EU provides a degree of a source in relation to the Constitution of the UK. There's also, of course, the non-legal rules of the Constitution. These are also constitutional conventions. I am going to save that till last because we are going to go through some significant aspects of this. We will look at certainly cases like Mazimba Muto, which is an important case when you look at constitutions and constitutional conventions. And of course, there are other sources of the Constitution. Let's just get rid of that first and dispense with it straight away. When we look at other sources, this tends to be the law and custom of Parliament type situation. So, for example, each House of Parliament regulates its own procedure, and it has certain privileges and immunities. Now, there are standing orders, there are resolutions, there are rulings by the Speaker and so on. And in general, we see that those rules provide for the workings of those houses, and again, are of constitutional significance because it provides for how the legislature is run. When you look at the ordinary courts, they tend to have no jurisdiction in these matters, meaning how, for example, Parliament is run. When you look at legal and constitutional literature, these are also a source, because if the courts are faced with an unusual or some sort of obtuse question of constitutional law, they may have to consider reference to the views of writers of certain reputation for guidance. Indeed, it may very well be that they draw on other jurisdictions. So the laws of other jurisdictions may in fact be a source, minor source nonetheless, but it is a source in respect of guidance. Now, when you look at legal texts, or you look at other sources from other jurisdictions like their case law, when you look at the authority, they can only be persuasive because the idea is that they are not part of the framework of the law in the UK. Now, when you look, for example, at Dice's introduction to the study of the Constitution and the writings, for example, of Sir William Wade in relation to the development of administrative law, they can only be persuasive sources. They cannot be this source. It gives you guidance in how to deal with certain constitutional matters. We now return then to constitutional conventions. these very quirky British custom type scenarios. Now, a constitutional convention is a rule, an understood rule of practice, which may apply to any of the three branches of the state, meaning, of course, the executive, the legislature, or the judiciary. Now, take for an example, the Queen must, by constitutional convention, give the royal assent to all bills which have passed through both chambers of the House. So, as long as a bill has gone through the House of Commons and gone through the House of Lords, it is that by convention she will give royal assent. The fact, though, is that it is in her prerogative to decide whether or not to give it. But convention, an understood rule, is that she will give it. Now, there's a range of definitions on what constitutes a constitutional convention. Now, most definitions will, of course, refer to the early works of the British scholar A.V. Dicey, as well as Sir Ivor Jennings, who investigated the differences between the law of the Constitution and the conventions of the Constitution. And this, of course, when you look at Jennings in his 1959 treatise. Jennings famously identified 3 questions to be asked as the precondition to the existence of a convention. Jennings says, first of all, you need to look at what are the precedents. Secondly, did the actors in the precedents believe they were bound by a rule? And third of all, is there a good reason for the rule? Now, if we take another scholar and look at Giaconelli, he says conventions are social rules that possess a constitutional, not just a political, significance. And he argues that emphasizing their social nature captures 2 of their fundamental features, which are their normative quality in prescribing standards of behavior and the fact they are not enforced in the courts. Those are their main qualities, he says. Now, their specific constitutional character bears out, in addition, the role that they play, which is similar to that performed by a written and legal enforceable constitution in its allocation of power. So what it is saying is, when you look at, for example, a state which has a written constitution, constitutional conventions have the same role, because what it seeks to do is to deal with the allocation of power and the control of the manner of the exercise of these powers as it falls between the organs of the government and, for example, political parties. Now, the nature of conventions and their relationship to the law is highly contested, but Marshall, writing in 2004, summarized it as looking at how these different organs interplay with each other and what the conventions provide for in this interplay. Now, conventions may come about in several ways. It may come about through practice, acquiring a sort of strong obligatory character over time, and it may come through the explicit agreement of the relevant actors. So when you look, for example, at the idea of parliamentary sovereignty, it is because the court gives Parliament its credibility that parliamentary sovereignty is a strong concept in the context of the British constitutional framework. So we're looking at here the sort of agreement of the relevant actors. Marshall says that conventions arise from a series of precedents that are agreed to have given rise to a binding rule of behavior. Now, on the other hand, a convention may derive from some acknowledged principle of government which provides a reason or a justification for that rule. Now, what we see in practice is that conventions may be confirmed after the event. Marshall says that many conventions are negative in form, connoting that political actors should constrain their behavior or refrain from certain courses of actions. So by convention, again, the Queen will not, pick up some arbitrary person to be the prime minister. So we see that conventions tend to regulate behavior. So what she would do is refrain from getting any old person to be the prime minister and stick to an understood line that it will be the person who is the head of the party who won the election. Now, a key characteristic of conventions, of course, and a key characteristic of the British Constitution is its flexibility. Since they are not subject to judicial interpretation, and because conventions evolve in response to changing circumstances and political values, we see that, of course, it tends to be somewhat flexible. What we see then is that constitutional conventions are not legally enforceable, although governments will generally be reluctant to breach them because of what may then ensue. So the likely repercussions will tend to be a limited or a chilling factor, as it were, when it comes to following or not following, as the case may be, these conventions. And what we do see from the case law is how this comes out in practice. Now, an important constitutional case that we will definitely consider is the case of Mazimba Muto and Lardner Burke in 1969. Now, before we go more in depth in the case, let's consider for a moment that given these non-legal rules, will they ever be broken? Do we think that they will ever be broken? Or even if they are going to be broken, what are the circumstances that they will be broken or breached, to use a more legal terminology? When will you seek to breach such sort of rule? Well, this is one of the things that the case of Mazimba Muto and Lardner Burke raised. And we are going to take a short break because it is a bit of an involved case, and so I want us to at least look at the factual background and what it provides for in the context of looking at it by way of a source, looking at conventions and how they actually work. We're going to take a short break, and as soon as we get back, we'll start off with the case of Mazimba Muto and Lardner Burke.